I'm Dan Kolkey. I am on the board of PRI and chair the PRI California Reform Committee, and am also a retired judge, although not of the Ninth Circuit, I might add. So let me introduce our speakers so we can commence. First, I am very pleased to announce that we have the attorney who herself successfully argued the case on behalf of Grants Pass in the U.S. Supreme Court, and that is Theane Evangelis. She is a partner in the Los Angeles office of Gibson, Dunn, and Crutcher. She's co-chair of Gibson Dunn's Global Litigation Practice Group. And by the way, she served as a law clerk to U.S. Supreme Court Justice Sandra Day O'Connor at a younger point in her career. And by the way, the Solicitor General during the George W. Bush administration witnessed her argument and told me personally that he thought she did a tremendous job in responding to the justice's questions, including hostile ones. Our next panelist is Erik Jaffe, who is also an attorney. He is PRI's Adjunct Fellow in Legal Studies, and he is an attorney who has handled or been involved in over 100 U.S. Supreme Court cases, and he filed an amicus brief in this very case in the Grants Pass versus Johnson case. And by the way, he clerked at a younger age for Justice Clarence Thomas. Also joining us is Wayne Winegarden. He is the senior fellow in business and economics at PRI. And he is also the co-author of No Way Home, which was PRI's book exploring the homelessness crisis in California. His columns, by the way, have been published in the Wall Street Journal, in the Chicago Tribune, in Investors Business Daily, and in Forbes.com. And finally, our moderator today is Stephen Greenhut. He is the director of PRI's Free City Center. He's a journalist who has covered California politics for 25 years. He was a full-time columnist for the Orange County Register and the San Diego Union Tribune, and he is presently on the editorial board of the Southern California News Group. He writes for the American Spectator and Reason magazines and has written a number of books regarding California's policies. So with that, I'd like to turn it over to our moderator, Stephen Greenhut.
Okay, well, thanks, Dan. Really appreciate that. Thanks, everyone, for joining our webinar. Thanks to PRI and President Sally Pipes for putting this on so that we can get a deeper look. As Dan had mentioned, the 2018 Martin versus Boise decision has hobbled the ability of cities to clear away homeless encampments, even as they've overtaken parks and public spaces. And that court ruled that enforcing anti-camping ordinances violated the Eighth Amendment's ban on cruel and unusual punishment, and cities needed to first have a place to house the homeless people before removing them. And then, of course, the U.S. Supreme Court's recent Grants Pass decision overturned Boise, and it's returned the policy appropriately back to the locality. So we're pleased to have such a distinguished panel, and let's just get right into it. Theane, how exactly did your firm become involved in these issues related to Boise and homelessness? I read that the firm had handled a variety of cases and that you personally are involved in LA County's Homelessness Commission. And so basically, I wonder how your longstanding concern about compassionate treatment informed your arguments and how you dealt with those in the homeless activism community who seem to want to portray you as a villain.
Well, thank you, Stephen, and thank you so much to everyone at PRI for having me today. This is an issue that has been incredibly important to me. I've worked for years with our local leaders here in Los Angeles. Our firm, my office is here in downtown LA, right in the heart of the city. And I've seen firsthand the just sad and truly tragic consequences of allowing people to camp on our streets. And it seemed to get so much worse in the last years. As everyone knows, it really has gotten worse. But I became involved in this issue right around the time that the Martin decision was, that case was decided by the Ninth Circuit. I was working with local leaders with the Central City Association, which is comprised of businesses as well as service providers, homeless shelters in Skid Row. I was working with them to help them understand the legal framework for around these issues, and working with city leaders, consulting on those issues, and on a pro bono capacity, just because I am interested in this issue and really want to help people. So this comes from a place of compassion. I believe that people should be treated with dignity, but I also believe that our cities need to be safe and clean and accessible for everyone. So I learned about the Martin decision, and at that point reached out to the city of Boise, because local leaders in LA, including our former mayor and others, were very concerned about what that decision would mean for the city's ability to address homelessness, and in particular, dangerous encampments that we saw starting to spread. So I reached out to the city of Boise and met with them, and got involved in the case. They were at that point very concerned about, how they would operate after the Ninth Circuit's decision. And we filed a cert petition in the Supreme Court. And at that time, we had dozens of amici that supported our petition, but the other side said, oh, there's nothing to see here. This is not going to be a big deal. It'll be easy. Cities will just have to build enough shelter, and then they'll be able to address encampments if they just build enough shelter. But of course, what the Martin decision said was it imposed a crude formula. It said that it would be cruel and unusual punishment for cities to prohibit anyone from camping until they had enough shelter beds for everyone. Right now in LA County, we have 70,000 by the last count of unsheltered homeless, and that is or unhoused, and that is just a staggering number to think about. So here in LA, it would be virtually impossible for the city to ever prohibit anyone from camping until they had enough beds for everyone. So that's exactly what ended up happening. Of course, the Supreme Court denied cert then. We were very disappointed. It was in, I believe, January 2020 at the time, but it was an issue where there really wasn't a circuit split. There hadn't been a lot of litigation yet under the rule. It was a new decision from the Ninth Circuit. So I think it might have been reasonable for people to wonder what it would really mean for cities. After that, I was appointed to serve on the Los Angeles County Blue Ribbon Commission on Homelessness. So my work continued in this area, and I continued working with local leaders and talking to cities all up and down the West Coast. And what I saw was lawsuits getting filed left and right. 35 lawsuits by my last count have been filed against cities in the West Coast. And that doesn't even include or begin to touch upon all the cities that received threatening letters that threatened lawsuits, and then cities changed their policies voluntarily to avoid injunctions and litigation. So cities have just been completely hamstrung. And I have to say that the consequences we predicted after Martin have actually, things have been even worse than we could have ever imagined. People are, unfortunately, were refusing offers of shelter, at least 50%, maybe 2/3, according to Portland's brief before the Supreme Court in support of our petition. So we've seen people refuse shelter, and then cities completely powerless to address dangerous encampments. So my work in this area is really, it's been something I've been committed to for years, and talking to local and statewide leaders like Governor Newsom, I understood that this was a compassionate solution, that cities need to have the ability to address encampments because it's unsafe for everyone, including those who are trapped in encampments. There is no dignity and there is no compassion in letting a person live and die in a tent. And that's just the reality. So I will take on any of those critics who think that that's a better solution than getting people into shelter and services.
Great. Well, thank you. Erik, I enjoyed the amicus brief you penned for PRI, and in it, you explained that constitutionalizing such simplistic rules can only hurt rather than help in finding solutions for the problem. Can you elaborate on that? And maybe just get into how the previous situation impeded localities from finding useful solutions, and how cities can now find better solutions, and will they, do you think?
Sure. Well, I seem to have frozen. There we go. Well, I mean, it seems to me, the example Theane gave just a moment ago is a good example of that, that you can't clear any homeless people until you have enough room for every homeless person. Seems like one classic example of hamstringing cities from at least taking partial steps to solve the problem. If I have 30,000 beds available, why can't I clear an encampment with 10,000 or 5,000 people? So that's one good example of not even letting cities take what steps they're capable of taking. Another good example was given in Justice Gorsuch's opinion, I believe in a footnote, where he talks about a city setting up an outdoor area near a warehouse where they had services and showers and people came in, and that was deemed inadequate. But the notion that it is better to be sleeping alone in a park or an encampment under a bridge than in a controlled space with shade and protection and services is absurd. The notion that that's somehow a Eighth Amendment violation. And it just goes to show that I love federal judges. I really do. I'm a big fanboy of federal judges, but they know nothing about public policy. Literally nothing. The notion that we would have a few federal judges decide how to tackle homelessness is insane. And the notion that they would do that in the name of the Constitution, which doesn't speak about any of this, of course that's going to hamstring the very notion of experimenting and trying different solutions, seeing what works, seeing this city does it one way, that city does it another. Maybe we'll find some third path. But the one thing I know is that federal judges in general, and the Ninth Circuit in particular, are the last people I want making these kinds of decisions for the country.
Yeah, I know in the rule, reading the Supreme Court's ruling, I mean, it just seemed absurd, the idea that a fine and jail time was only, you'd only get maybe 30 days in jail if you're a repeated offender. And the fact that that was a cruel and unusual punishment just seemed like such an oddity to me.
Well, I mean, that's certainly true that from a historical perspective, from a technical perspective, this opinion nailed it on the head, that the Ninth Circuit really got that wrong from any kind of ordinary constitutional analysis you wanted. But I think what is missed is that even if you think punishment is not necessarily the best or the first answer to homelessness, it is one of many tools. And if nothing else, it is an encouragement to get people to accept some of the other tools that they might resist, but for the implied threat of a fine or some other sanction. So no one's saying that the way to solve homelessness is to threaten them and punish them until they stop being homeless miraculously. It's just one more tool in the toolbox that I think cities and states need.
Yep. Okay. And Wayne, as a journalist, I've talked with a number of city officials who have been frustrated over the years by the way Boise hamstrung their efforts. Some of them maybe even just used it as an excuse not to do anything. But can you chapter and verse how Martin versus Boise harmed them and how Grants Pass has freed them? I guess I'd like you to focus on some of the things they can do now. What specifically might they be freed to do?
Well, I think Erik hit the nail on the head when he talked about, going with that analogy, tools available. One of the things when you dive into the issue of homelessness, and this is what we've discovered in all of our research, that we've been really looking into this issue for years, is that it's multifaceted. The problem is multifaceted, and that there are very different types of individuals. People become homeless for many reasons. Not only do they become homeless for many reasons, but being homeless creates its own problems. We were at a shelter and we were talking with the director, and one of the things she told us, and it was just fascinating, that after you've been on the street for 30 days, that even if you weren't having issues of addiction or didn't have mental health problems before you became homeless, either became homeless for economic reasons, let's say, being on the streets, having to survive on the streets, it drives you to drugs. It is very incredibly stressful. So it creates mental health problems. The bottom line is it's a very complicated problem. Diverse people are homeless. And so we need as many tools as possible to help them. And so what the Martin versus Boise did, and I always feel very, very difficult to talk about legal issues with two such great legal scholars here, but what it did is it prevented one of the more important tools. And we need carrots and sticks. And one of the important sticks is being able to clear homeless encampments. And there's a lot of, from an individual perspective, there's a lot of reasons why people may avoid shelters, right? Especially women, where, shelters can be violent. There's incidents of rape. There's a lot of problems, and those things need to be dealt with. But losing that ability to clear the encampments is taking away an important stick that helps some people who need help but won't seek it. If you have a stick available to you as a city, you can then get those people, possibly involuntarily, but get those people the help that they need. And so I think when you're talking about options, that's what's really important about the Grants Pass decision. It doesn't solve the homelessness problem at all, but it allows more options, and it opens the door so that the localities now are better equipped to address the problem. But we're not going to get progress unless we walk through that door.
Okay, thanks, Wayne. Theane, I was on the Ninth Circuit's finding of cruel and unusual punishment. It always seemed like a strange overreach. Do you have any insight into how they came to that? Do you think they just concocted it to impose, maybe a solution they already had in mind? And how did you rebut that argument in court? Was there anything you said that you thought was particularly effective in rebutting that particular point of reasoning?
Well, when I try to tell people about the case and what the theory was that the Ninth Circuit relied on, this theory of the Eighth Amendment and cruel and unusual punishment, I think people are just shocked, and they scratch their head and they think, how in the world is it cruel and unusual punishment for a city to have on its books a municipal civil ordinance like the one in Grants Pass and like those that are in cities all over the country? That was something that we showed and Amiki showed all over the country, from West Hollywood, California, to Watertown, Massachusetts. I think I said that at the argument. Cities have ordinances just like those in Grants Pass that say that you may not camp on public property, and usually the punishment is a ticket, a civil, like a parking ticket. And for recidivists who continue to violate those laws, then they could be guilty of a misdemeanor of trespass, and that could be an increased fine or 30 days. And the reality is that no one's getting jail time for these sorts of offenses. It's just a tool that cities can point to and say, this goes to Wayne's point and Erik's. I mean, this is just so important for cities to be able to say, we have something better for you, but you may not continue to occupy this public property. And that's exactly what the mayor of San Francisco just said after the argument. And so, just kind of thinking about what this is that we're talking about here. This is not the death penalty. We all think of the Eighth Amendment in the context of the death penalty and maybe life in prison without parole or certain punishments for juvenile offenders, but it's never been extended to this sort of local law. And so the way the Ninth Circuit got there was this theory that somehow laws that regulate camping punish people for the status of being homeless. And they relied on a Supreme Court decision from 1962 called Robinson versus California. It was a sort of strange outlier decision where the Supreme Court struck down a California law at the time that had made it a crime simply to be addicted to narcotics in the state of California. There was no act requirement, nothing that you had to do to violate the law, but you could simply violate the law just by existing in California as an addict. The Supreme Court struck that down. And at the time, we researched this at length in the briefing, and it was fascinating to me when I looked at the briefing that was filed on behalf of Robinson, the petitioner. The brief devoted almost no space to the Eighth Amendment argument. It was just sort of thrown in there. The whole case was about due process. But I do believe that in the wake of the rejection of Lochner and substantive due process, I think the court was looking for another hook, a different hook from due process. This never came up in the argument. Robinson's counsel didn't push the Eighth Amendment theory. So it was very strange when the Supreme Court ruled under the Eighth Amendment cruel and unusual punishments clause that California's law was unconstitutional. It was the first and only time that the Supreme Court applied the Eighth Amendment to the substantive regulation of conduct. So what a state or local government could prohibit within its borders, as opposed to the punishment that they imposed. It was always and forever understood as applying only to punishments. So it was strange when the Supreme Court decided that case. But then just a matter of a few years later, in 1968, the Supreme Court in the Powell case, Powell versus Texas, really shut the door that Robinson had opened. And in a really compelling concurrence by Justice Thurgood Marshall, the court said that there, a Texas law that prohibited public drunkenness was constitutional, and it did not punish the petitioner for his status of being an alcoholic. And Marshall's opinion goes on at length to talk about how if the court were to rule otherwise there, it would put federal courts in charge of criminal law all over the country, and federal judges would be in charge of deciding what prohibitions were constitutional or not, and really making policy decisions that should be left to the states. And it was only a plurality opinion, but everyone thought that that was the law until the Ninth Circuit in Martin v. Boise resurrected really the dissent in Powell. The dissent by Justice Fortas had said there that that conduct of being drunk in public was tantamount to a status crime because the person couldn't control his conduct. It was involuntary. So the theory was somehow that involuntary conduct cannot be prohibited because a person is powerless to change that status and their conduct. They can't control it. But of course, that wasn't the majority. It wasn't the controlling opinion in Powell. So it really left people scratching their heads when the Ninth Circuit seemed to resurrect that. They relied on a lone concurrence by Justice White that sort of was a little bit ambiguous. Anyway, I won't get into all of the details there, but suffice it to say that really our whole theory in this case, our legal arguments were really Justice Marshall's view of the Eighth Amendment in Powell. And that's what Justice Gorsuch's opinion in Grants Pass endorses, and it discusses Powell at length. So that was really a vindication for us. You know, we said all along that Robinson did not go as far as the Ninth Circuit and the plaintiffs and respondents in our case were arguing. We did not ask the court to overturn it. We said that the court didn't need to because really our case was nothing like the law in California. Our case involved conduct, the conduct of camping on public property. And to take that whole category of conduct off the table just because someone argues that, you know, it's involuntary somehow, I mean, that would really that would really be the dissent's view in Powell that was rejected. So in a nutshell, that was the legal issue, and that was how we approached it.
Right, and the court pointed out that I could be arrested for public camping in Grants Pass if I decide to spend the night in the park, right? It's not targeting people for their status. It's targeting people for what they do, right?
Exactly. And that was such a big part of what we argued to the court. And the amicus briefs just did a great job of explaining that these are laws that exist everywhere, as I mentioned earlier. And this is about conduct. And there are federal regulations, for example. I tried to bring this up in argument, but I got cut off a number of times, but it made it into the opinion. So I did bring it up, but I didn't get a chance to speak much about it at the argument, but it made it into the opinion that the federal regulations that govern federal parklands and including parks in Washington, D.C., like McPherson Square and others, where the National Park Service clears dangerous encampments all the time. The law in Grants Pass really is exactly the same as the federal regulations. So these are generally applicable laws that apply to the backpacker walking through town, or someone who maybe refuses an offer of shelter or is homeless for whatever reason. These laws apply to everyone, and the Supreme Court made that very clear. And I think the court was really concerned about the practical consequences. And I know we're going to talk more about this, but I think the court's reliance on amicus briefs and sort of the experience on the ground over the last 6 years under the Martin regime really was very telling. That the court was the legal issues, I always said, and I think I said this in my rebuttal at the very end, the legal issues in this case actually were not that hard. The Eighth Amendment question was easy. The policy questions are the tough ones. And the court's opinion said exactly that. And I think that's really what was so important here.
Yeah. Okay. Thank you. Erik, you also argued in your brief that, quote, inserting the unmoored policy making of the federal judiciary into the mix is not the answer. Well, what do you think the court was trying to do? Do you think they were trying to force cities just to build particular types of housing? And, and why is that inappropriate?
Well, I'm sure that was a good chunk of it, that they saw this problem that wasn't getting solved by the political process, or at least not solved to their liking or as fast as they would have preferred, and sort of felt like, let's do something about it. And I'd say that while I think the issue as framed in Martin and as framed in City of Grants Pass at the Ninth Circuit level was utterly misguided, the basis for it comes from a slightly different doctrine of sort of disproportionality and involuntariness, which really is a due process problem in my mind, not so much an Eighth Amendment problem. We've occasionally talked about it in the Eighth Amendment context. And I think judges can get their heads wrapped around these sort of adjacent legal theories and misapply them in the Eighth Amendment context. So no one would think it would be okay to throw someone in jail for having brown eyes, right? We would call that disproportional. Or executing them for having brown eyes. That would clearly be disproportional. There's a history of Eighth Amendment jurisprudence about that. I kind of think it's probably better dealt with in the Due Process Clause. But they got their head around this as if it were that. These are involuntary status things, and punishing people at all for an involuntary act is arguably disproportional. And that's how they got stuck in the Eighth Amendment. It's not what they held. It's not what their opinion said. And had they said that, it would have been easy to rebut, because those kinds of claims tend to be dealt with on a retail basis. Well, I was there in the middle of the park. Someone knocked me out by clubbing me over the head. I ended up asleep on the street. Obviously, you wouldn't arrest somebody for that. It wasn't voluntary. But this was a stretch of that. So I think that's how they got there. I think they were driven to do that by, admittedly, a compassionate sense that somebody needs to do something, and it doesn't look like the states are doing enough. But that just oversteps the bounds of a federal court. Those kinds of questions should be dealt with by local governments, by state governments, even by the federal government if necessary, especially as it impacts interstate commerce, let's say interstate highways, if you're camping out along highways or in federal parks. And I think at some level, even by state court judges who do have some common law authority to apply doctrines like involuntariness, justification, duress. There are all kinds of common law doctrines on a case-by-case basis that state court judges could apply, subject, of course, to statutory override. So I think it's just federal judges appointed for life with a lot of power sometimes get carried away, and I don't want to be overly harsh of that. It's you can understand the urge, but really, sort of the lifelong project of my legal career has been constraining these kinds of let's get into policy by federal judges.
Yeah, I've seen, like in Orange County, one federal judge, and it seems like it was motivated by, from a good place, but has been actively involved in using that power that he has to kind of foist specific policy solutions on the county and local cities. So I'm wondering whether maybe the court ruling here might rein them in a little bit.
Yes, it will rein them in a little bit. But look, this is a common back and forth push and pull between the Supreme Court and some lower courts. There's a certain level of hubris is too strong a word, but you're a very smart person who's been appointed to be a federal judge, and you're listening to arguments, you make decisions all the time, and somehow you think that translates into, well, I've heard the arguments, and this is obviously the best solution. Stephen Breyer was probably the best example of this on the Supreme Court in recent answers. Let's just do that. And so, yes, it'll constrain them for a little bit until the next thing, and then we'll have the push and pull once again, I suspect.
Okay, thanks, Erik. Wayne, let's get into some of the real world outcomes here. So Governor Gavin Newsom, who of course did an amicus brief on the correct side on Grants Pass, has been issued an order to impose the Caltrans approach of cleaning up homeless, to state agencies to clean up homeless encampments throughout the state. And then he's also suggested to localities that they do something similar. So I'm just wondering what you're going to see happening now, and if you could touch on housing first and why that's been such a disaster. Because part of the problem is the governor's been saying, "Hey, we're building housing," but the housing they're building costs what, $600,000, $700,000, $800,000 a unit, and we're not going to be able to build enough of it to move people into these places.
No, 181,000 people who are homeless times $600,000 a unit is a very, very large number that California just can't afford, which is just one of the many problems with housing first. I guess going to your first question though, when you're looking at, now that Grants Pass has occurred and you're actually beginning to see different approaches, like Orange County, they're going to be going the route that Governor Newsom is doing in terms of clearing the encampments. The mayor of Los Angeles, she has explicitly stated that they're not going to. So I think we're at least initially going to start seeing a diverse kind of approach to this. From a policy perspective, that's very fascinating because we're going to really learn the importance of clearing encampments versus not clearing encampments. Take LA versus Orange County. If we start to see distinctly different kind of results, that will be important lessons that we should apply not just statewide, but nationally in terms of we're learning how best to address the issue of homelessness, not just for the betterment of the cities and the other residents, but also for the betterment of the homeless themselves. So I think we're, at least initially, it seems very clear we're going to have different approaches. And my guess is that those cities and localities that are clearing the encampments are going to see better results, not just economically, not just socially, but also for the homeless themselves. But we'll in a couple of years from now, we'll have results and we'll be able to see what happened. In terms of housing first, and I think this is another really important part of Grants Pass decision, is that we can no longer kind of pass the buck. We can no longer put our hands up and say, well, we can't really do anything. So now there really is no excuse. There's nothing to hide behind, which is why I think you see the position of Mayor Breed and the position of the governor. They're realizing, I have to take control of the situation, and clearing the encampments is a first part of it. I think what also we're going to run up against is housing first. Just very quickly, the premise of housing first, for those who don't know, is there is a good theory behind it, right? What it says is a stable home is the best place to provide the services and the treatment that people need. Therefore, first we prioritize getting a permanent home, and then from that platform, we can then help people address their issues, get them kind of sustainable and off on their way. The problem is that that's a great theory, but in practice, it doesn't work. One, like you said before, the costliness. It's so costly. You can't spend $700,000 per unit and hope to anywhere get close to solving the problem. You also have, and this kind of interrelated to the cost, it doesn't become housing first. It becomes housing only, just because you run out of money. And what we've seen in a lot of the housing first, like Project Room Key, Project Home Key, is that the drug use and the other types of problems that were in the encampments have just been moved to the converted hotels or the other, homes. So all you're doing is moving things around. You're not actually addressing the root causes of the problem, the addiction, mental illness, things of that nature. You have rampant drug use. I mean, you have incidents of staff coming in facing violence because these areas can be very violent. So all you've done is relocated the problems. You haven't actually addressed the problems. And you actually see that in the results where from housing first, a majority of the people aren't actually moving on to permanent homes. A lot of them fall back onto the streets. An even larger amount, we don't know what's happening. Right? And that's an interrelated problem, but we're not actually, we don't have oversight over this. So we're spending a lot of money and not knowing what we're doing. So, for all of these reasons, housing first is failing. But I think the great thing, kind of going back to Grants Pass decision, is now that we're in this new environment, you can't keep failing with housing first. because now you're responsible. Now you have to do something. And so if Housing First continues to cost too much or continues to fail, there will be pressure to try something different. And I think that is something that's exciting in this new environment.
Right. The cities can't just say, well, my hands are tied. So, okay. Well, thanks, Wayne. Theane, I'd love to get some insight on what it was like to present before the court, what you thought of the line of questionings, and what insights you believe that the line of questioning offered, when you were going through it, whether what they were saying, whether you saw that in the end result. And, so yeah, provide some insight, because obviously not many people get to argue before the high court.
Right. Well, the argument lasted more than 2 hours, and that was a big shift from when I clerked on the court, because under Chief Justice Rehnquist, counsel were limited to 30 minutes per side, and he would cut them off mid-sentence if they went over. But it's very different now, as you all know, with the seriatim questioning by all of the justices at the end. So I was at the podium for over an hour, and the Solicitor General's office filed in support of neither party, but really, in our view, in support of the respondents, in support of the other side, really for all intents and purposes. And so they took some of the time from the respondents, and it was just fascinating to see, the government was at the podium for almost an hour. And then by the time the justices got to respondents' counsel, I think that was the shortest argument, because we had already really addressed all of the, so many of the questions and the important issues by the time they even got to the podium. So it was really a very intense argument. I have to say it was really interesting for me, because I felt that the justices really were grappling with the practical consequences, and that, at one point, the chief asked, why should the 9 of us here be the ones to decide these really difficult policy questions? Exactly what we're saying. It seemed that the court really understood that this was a bridge too far when it came to Robinson. And sure enough, while the court did not overrule Robinson, it really endorsed the Powell concurrence or plurality, by Justice Marshall, and that was what we had argued. But I really did not get a lot of questions about the law, about the founding. I had studied vagrancy laws and the history of vagrancy at the time of the founding. I really felt like I was an expert by the time I got to the podium on all of that history, on the tradition, on all of the things that we usually resort to for constitutional interpretation. It felt like the hour was mostly spent with practical questions. Is a prohibition on camping in public if you're homeless akin to outlawing breathing? Is what if someone, at one point, I think the government was asked, what happens if someone steals if they're hungry? Is that an involuntary act that then should be excused? And, I think the very unsatisfactory answer that the attorney from the Solicitor General's office gave was, the homeless are resourceful and will figure out ways to get food. So that's distinguishable. I mean, it was very obvious that there are endless line drawing problems, and that once you say that it is constitutionally protected behavior because it's purportedly involuntary, then you go down a very slippery slope. But, I got lots of pushback from Justice Sotomayor in particular, Justice Kagan also Justice Jackson. They were very they were very critical of our position. It was very clear to me. I think, at one point, Justice Kagan asked me early on in the argument if homelessness is a status. And I said no, and that it would not, and that it is not an Eighth Amendment violation under our view of the Eighth Amendment for for cities to. She asked, could they outlaw homelessness? And I said, well, that might raise all sorts of constitutional problems, but not an Eighth Amendment problem. And that was, a point where I think, I really held my ground, and I thought it was very important, and I believe that was the right answer all along in our briefing and an argument to hold our ground. ground that homelessness is not a status like being an addict. And even if you leave Robinson exactly where it is, these laws that address camping, because camping, of course, is conduct that can be engaged in by everyone, and homelessness is very complex, and someone's condition might change from one day to the next. And the Chief Justice asked me about this, asked about, well, if someone one day is homeless and camping, and then the next day they're offered shelter, well, then, that means they're not homeless anymore, are they? And I think the answer actually is, well, at that point, they're sheltered homeless. There's all sorts of definitions of what it means to be homeless. And, it is not a status that is a permanent status, an immutable characteristic, or anything like what any of the other cases had dealt with. So I think that was really important to hold our ground on the meaning of the Eighth Amendment. And we took the position that the Eighth Amendment always was intended to address only punishments and the form of punishment and the severity of punishment, but not the actual conduct that can be prohibited. And I think that was where, the court saw it as well. But the whole argument was really about line drawing. At one point, Justice Kagan asked the government's lawyer, well, you say that it's a biological necessity to have a blanket in Oregon because it's cold. So when you're camping, a person needs a blanket. But what about a really cold climate? Or what if it rains? Are people entitled to have tarps? Are they entitled to start a fire? I thought that was very interesting. Unfortunately, Justice Kagan joined the dissent, and the dissent doesn't grapple with any of those problems, any of them at all. And so I was surprised to see that they really didn't have an answer or didn't, come up with one, but I don't think one exists. There really isn't an answer to that question. It really would just be, constitutional law by fiat. It would be judges just guessing and making up rules. And that's exactly what we saw under Martin in those 35 cases that I mentioned. I use the example of the city of Chico. Erik, that's the one you mentioned, where the city set up safe and clean and regulated campsites. And the federal court in that case said that was nonetheless an Eighth Amendment violation because it was outdoor shelter. But of course, we all know that encampments are outdoors too. So I don't know how that was any worse than what people were where people were before the court's decision. So, we just saw endless problems with line drawing and no notice to local governments. And the court really listened. The majority opinion cites amicus brief 64 times. It repeatedly cites Governor Newsom and Mayor Breed and so many other progressive Democrats from cities all along the West Coast within the Ninth Circuit who really found that they could not address these problems because they were getting hit with lawsuits left and right, and that federal judges were deciding that their solutions and their shelter options and other solutions were inadequate. And so if they weren't adequate, they violated the Eighth Amendment by preventing someone from camping. And so it really created a right to camp. And the court was mindful, I think, about the impossibility of drawing these lines. And, I'm going to read a quote from the decision. The court said in the majority opinion by Justice Gorsuch, as sometimes happens with abstract rules created by those far from the front lines, the Ninth Circuit's test has proven all but impossible to administer in practice. And that's exactly what happened. And if the court had agreed with the respondents and with the Ninth Circuit here, the entire country would be under the Martin regime. And just think about how awful that would be. So that was the alternative to our win here. It would have been a disaster. And I think the court was really aware of that.
Oh, okay, great. Thank you. Erik, have you looked into the care courts at all? To me, that seems like, one of the interesting solutions that maybe will be empowered by grants passed, because localities can arrest people, but not sentence them to jail, but sentence them to treatment. And that's something that I know the state has come up with in recent years. There were some counties already had care courts, but have you thought about that and how that might work now?
I haven't thought about the specifics of those courts, though in the PRI brief, we do make a passing reference to this concept by pointing out that if someone is really involuntarily homeless, as in they're not capable of taking care of themselves and their health and their well-being, that sounds like a recipe for civil commitment to me. And so if you really believe that there is no volitional behavior going on and they're stuck outside encampments, I think you need to take those people in and give them some care. And maybe the care courts are a way to do that with a decent amount of due process and, with some compassion. So while I haven't studied those courts specifically, it certainly is, it sort of hovers on that line when we start worrying about what's voluntary, what's involuntary, things that the common law has struggled with for centuries, and in various and sundry doctrines, but that we as a country have also struggled with, the ACLU famously, taking on involuntary commitments for mental health reasons. So we should, it's a good experiment. We should obviously be careful of the abuses of the past, but I think it's true that if folks can't get themselves out of the cycle, at some point voluntariness ceases to be the touchstone if they're not acting in a way that they really can control.
Yeah, I know when we talk about homelessness a lot, people often want to go to that's the tough issue, the involuntary commitment issue. It seems like, though, the state and cities haven't done a lot on dealing the low-hanging fruit, right? Getting rid of the more the bigger part of the problem without even having to get there. That
it's hard to know what the low-hanging fruit is. So I always think back to Santa Barbara, where they're very generous and welcoming. They have a lot of services for homeless folks, and inevitably that attracts homeless folks. So whatever number of houses and beds and facilities they have, more people come, and then it overruns the capacity, and then you have to build more and more and more. There's no low-hanging fruit here. There's a problem of incentives. There's a problem of resources. There's a problem of distributing the governmental structures around so that you don't have, one place bearing the burden of everything. I don't know that there's a lot of low-hanging fruit. I agree, though, from a city and livability perspective, having people in encampments where there's drugs and violence is a really bad idea. Whatever you think the next best solution is, that solution is pretty bad.
Yeah, that's a good point. My daughter lives in a liberal town in the Pacific Northwest, and out of the goodness of their hearts, neighbors started bringing food and things to folks who were camping in a vacant lot. And before you know it, it went from 10 families to overrunning the whole neighborhood. And I think that's a lot of the things that people have been concerned about. But I do have a question from one of the audience. So let me just read this here to whoever wants to take it. Can the courts finding that municipal governments can take reasonable action to prohibit and remove illegal occupants of public property be extended to empower communities, neighborhoods, businesses, or residents of local jurisdictions to compel local governments to take action to remove encampments from public property rights away and so forth? So I guess they're trying that. I like that question, and they're trying to get into, what do you do beyond public property? And as you get into, some of the private, private neighborhoods. So maybe Theane, would you have an answer on that? Or?
Well, I think even, I think this is public property when we're talking about sidewalks and
Sure.
neighborhood parks and so forth. And we've seen all of those areas really become overrun by encampments in our cities, small and large, all across the West Coast. I mean, we saw Grants Pass is a city of 38,000 people only, and its parks looked like those in LA and San Francisco. So I think we saw Governor Newsom's executive order. I think it will probably be a matter of state law of what at the state level, what they can force local cities to do or not. But most important of all here is that the political process should be the place, and local government, city councils, state legislatures, that's where this debate should play out. And that's where people, voters, where businesses, where residents, and communities can speak up, and they can try out different solutions. And so I think that it'll be interesting to see what sort of back and forth happens now between state and local governments. And we're seeing that already in California.
Yeah. And one question we had talked about before we went live, which is, what does this mean for Oregon and for Grants Pass itself? I read one piece that was saying because the legislature codified some aspect of Martin versus Boise, that it might not have as much impact in Oregon and Grants Pass as it might in states where the legislature hasn't done such a thing. Could you walk us through that, the Oregon situation in particular?
Sure. Well, right now, Grants Pass, until the case goes back down to the district court, presumably, at that point, I'm sure the injunction should be dissolved against Grants Passes, and that rested on the Eighth Amendment, on the Martin rule, and that was a decisive win from the Supreme Court. So Grants Pass should no longer have an injunction. It will have to comply with state law, whatever that means. The state legislature enacted we'll call it a time, place, and manner rule that will impact local government's ability to regulate encampments. They'll have to comply with the Oregon state law. That's much more permissive than what the Ninth Circuit had held, of course. And it's not a constitutional question. It becomes a question of state law. And the Oregon legislature can repeal that law, or they can change it. So I think it's a good thing to have states try different approaches. It will be interesting to see what happens statewide in Oregon. That statute, that legislation that you referenced, Stephen, that has not been litigated. I don't think people know exactly what will be permissible under the state law. So we'll see what happens there. But that wasn't presented in our case, of course, and I don't think there have been any court decisions interpreting the law. So it's a big question mark, and it's subject to change. So that's the good news.
Yeah. Okay. Thank you. Now I want to jump over to Wayne. You've toured a number of homeless facilities, ones private ones that are working, and I'm just wondering, what are some of the right solutions? What should cities do in terms on the solution end? We know we need the stick as well as the carrot. What's the right carrot?
Well, I think there's a number of things that are being done that are quite exciting, and I think we should also recognize that there are probably things that we don't know that somebody's going to try, and we need to be open to innovative solutions that we haven't thought of yet. I think one of the most interesting things that at least I've seen was this group called Dignity Moves. And what they've done, which I thought was pretty fantastic, is they were able to build individual units. Because one of the things they identified is the fact that people don't want to go to shelters because of the violence and all these other types of problems, because of lack of privacy, because a lot of homeless people, they have dogs, right? Dogs aren't welcome in a lot of shelters. So there's obstacles. And what they built, and it's much more cost effective, is small little homes. And it's temporary. It is really just kind of one room and has a bed, a desk, it's clean, there's shower facilities there, there's food, but it's individual. You can lock the door, so you have privacy, you have security. If you have a couple, they can be together, bring your dog if you have one. So they've never had one person turn down a place at this kind of, I wouldn't call it a shelter because it's really just a community of homes that can be moved around. And what was really fascinating is, one, it was cheaper. You're talking about $25,000 per unit. It could be moved to where it's necessary. And you can also, that money, you can kind of segregate so you can actually provide the services that people need. And that's the more important issue, right? This has got to be a stepping stone to helping people kind of gain that kind of sustainability. And so you can do that much more cost effectively. And that's just one type of solution. It's by no means appropriate for all, but it's innovative thinking. It's how can we do this better, cheaper, and make it scalable. And there's all sorts of innovations like that happening, not just in California, but across the country that we need to learn from and apply. I think the more important thing, most of those are happening kind of in private nonprofits. And so the question is, how can the government, state government, which is good at spending money, but not necessarily good at running programs. So how can we use those nonprofits to kind of use our resources better? And I think that's kind of an important, how do we do more with less?
Well, our state's also good at doing audits of the government spending to see how it was misspent. But one of the things I had thought was some communities, they built temporary housing facilities with social services. And now it seems like after grants pass, this might empower them to be able to move people out of the downtown and then have a place to take them. It seems like the two maybe could work hand in hand.
Oh, absolutely.
Which seems like the most sensible thing I've read. Now, I've got a question from the audience. Will Governor Newsom's recent executive order mean that Caltrans will be more aggressive in clearing the rights of ways around freeways? Anyone have a sense of how that might work?
Well, I think the answer is yes. I think we're already seeing the immediate impact of that. And, you know, I just want to be clear. I mean, this is about approaching the problem with compassion. People are being offered alternatives. So, you know, no one is just being rounded up and sent to jail. That's never been what anyone wanted to do. It's never happened outside the Ninth Circuit or in the Ninth Circuit. And that's not what this case was about. This is about connecting people to shelter, housing, services, and getting them the care and the help that they need. But the alternative is, you know, shouldn't be that you just get to live on public property without getting that help. So I think that's been Governor Newsom's approach, and that's what is driving that executive order. And I think we're going to see immediate results. We already are. And I'm hearing it every day from people all over the state.
Great. Well, I think we're running out of time, and I want to thank the panelists and Pacific Research Institute for putting together this thought-provoking panel. I want to do a quick pitch for the Free Cities Center, which we deal with homelessness and urban issues. And I want to thank, I want to remind everyone to join us on Saturday, September 21st for PRI's annual Sir Anthony Fisher dinner with the special guest Kimberly Strassel from the Wall Street Journal. And you can go to pacificresearch.org for information and tickets. And we just want to thank everyone, thank the panelists, and thank PRI, and thank you for participating in our webinar.